Thank you. That metadata brings up just one quick question I'll inject. You mentioned the disclaiming of AI produced. Can you envision that along with disclaiming that they include the metadata that shows what they ingested, how it turned into what they produced that they're disclaiming? Are you considering that within your IT modernization?
That's a very interesting idea. We have not yet considered it. We generally have been trying, however, to make the application for registration as easy and simple as possible, and have heard some concern that we might be asking for too many details, and people would prefer that we make it still easy to fill out an application without having to provide a lot of information. So we have to keep that in mind as we look at that.
Thank you. To be continued. With that, I go to my colleague and classmate of many years ago in Congress, Mr. Schiff.
Thank you, Mr. Chairman. Thank you, Director, for being here. Earlier this year, it was reported that Tik-Tok was limiting the number of songs available within its app for some users in Australia in an attempt to test the importance of music to the app's users. As a result, the number of people using Tik-Tok in Australia declined for 3 consecutive weeks after the rollout of the test, according to numbers from the data research firm Data AI. The test revealed what many creatives already know to be true. Much of TikTok's success can be attributed to copyright works by musical artists, many of whom I represent in my Los Angeles district and who are often undercompensated for the use of their work on TikTok's platform. Director, in light of what we've seen in Australia and what it suggests, what thoughts do you and your office have about how the United States can ensure that creators and rights holders are protected when their work is used on digital platforms?
Well, this is obviously a top priority for all of us in the copyright field, and we've done a number of things over the years to contribute to that effort. We, of course, don't have enforcement capabilities in the Copyright Office, but we do provide input from a policy perspective on what the law should say. And that's included over the last few years, our report on Section 512 of the DMCA and some improvements that could be made in that section, as well as looking at how copyright owners are using technological measures to identify and protect their works. We continue to be interested in that and to look at ways that we can convene interested parties to continue to discuss improvements. We also continue to follow and review what other countries are doing in this respect and what tools have been adopted elsewhere that could be useful to American right holders. Finally, we work closely with the executive branch on initiatives that have to do with international enforcement, including the U.S. Trade Representative's Special 301 report and Notorious Markets report.
And in terms of TikTok, do you think the remedy is primarily an enforcement one, or are there legislative changes you've recommended as a policy matter?
We have not to date looked at potential legislative changes, and I have not been made aware of any proposals from stakeholders, but would be interested in hearing more about it.
Let me turn to something else. Earlier this year, the Supreme Court decided the Warhol versus Goldsmith case dealing with fair use. How do you think that decision impacted or clarified the way courts are supposed to apply the fair use analysis? And how do you expect this ruling to impact any future rulemaking from the Copyright Office regarding the use of copyrighted material to train AI models?
We agree with the Supreme Court decision, which adopted a lot of the analysis of the U.S. government. The government participated in that case as an amicus. It may be that the case will have an influence on the fair use analysis of the ingestion of copyrighted works for purposes of machine learning. It requires, well, it affirms the need to look at the markets for both the original work and the work that is based on the original work, the work that is the subject of the infringement claim, and to look at the extent to which they are competitive, that they share the same market, and the extent to which the defendant's use is commercial in nature. So how that will apply to the analysis of fair use in the ingestion of copyrighted content for AI training is still up in the air, but it will certainly affect it, and we are watching the court cases to see how the courts react. We have asked questions about this in our notice of inquiry, and we will be analyzing it once we receive the responses as well. But it does seem as if it will have an impact.
Well, certainly by those measures, whether it is in competition in the marketplace, that test, I think, would be met, and that it's economic in nature is also plainly the case. Well, thank you, Director. Appreciate your work. And with that, I'll yield back, Mr. Chairman.
Could I ask you to yield to me? I just wanted to follow up on one thing. You said fair use and then said use in commerce. Would you like to expand that linkage, that fair use for not commerce,